As far as the rest of the Fourth Amendment, probable cause, again, is that standard that more likely than not, that there's a reason, a cause to believe that a crime has been committed. That is available through several different avenues. One is simple police observation. If a police officer is on the street and sees what he believes is a drug deal, a criminal offense, if he sees someone hit someone else, a battery, that's probable cause to believe a crime has been committed, and he can come up and make an arrest right away with no additional information. Now, there's another standard out there, and it's called a Terry stop. It's out of a 1963 United States Supreme Court case, Terry versus Ohio. And officers, if they have a reasonable suspicion, now that's below probable cause, but if they have a reasonable suspicion that criminal activity is going on, have the right to briefly detain the people who are involved in that activity in order to investigate whether there really is criminal activity going on. This is basically suspicious behavior. The facts in that Terry case from back in the 60s were a very experienced detective was on a city street, and he saw 3 suspicious-looking men. And they were meeting and talking. And one at a time, they each went into a shop, stayed for a few minutes without buying anything, came back and spoke to the other 2. And as this experienced detective saw that, he never saw a crime. He never saw a gun. He never saw drugs. He didn't see anything other than what, in his experience, was suspicious. Because to him, 3 guys standing outside a store and going in briefly and then coming out and talking about what they saw without buying anything looked like 3 men who were planning to rob the store. They were casing it and preparing themselves and getting more information. Now that's a reasonable suspicion. It's based on police observation, but not of a crime, not of someone being hit or a gun being flashed. So that enabled that police officer to go up and detain those people. Not say, hey, may I speak to you, and try to get a consensual encounter, but to actually say, you guys stay right here, I want to talk to you. Since this officer in Terry believed that he was observing what might have been an armed robbery, he actually wanted to pat those suspects down to see if they had a weapon. And he did, and the Supreme Court said that's okay. He can pat them down because he saw what might have indicated that they had weapons. It would have been a clear, serious threat to his safety, and he did that. And it was okay, and those individuals ended up getting arrested for having guns, and a crime was avoided. All through very reasonable, very responsible police action, good investigation, keen observation, a smart officer with a lot of experience putting it to work. That does not mean that an officer can at any time walk up and pat you down. A Terry stop can be abused. An officer cannot come up and say, hey, I just want to see what you're carrying with you. Stay right here and put your arms in the air so I can pat you down. So if you don't want your pockets rifled, not because you're committing a crime or think you might be committing a crime, but if you just don't want a police officer rifling through your belongings, act respectful, be honest and upfront, and assert your rights. Don't give him any reason to fear you. And he can't do that. If an officer's walking through a concert venue and sees a bunch of young-looking kids huddled around and appearing to be drinking, that might be alcohol that they're drinking. That might be illegal. He can go over and say, hey kids, step back, I want to see what's going on, and make them stay there. The minute he sees that it's Coca-Cola and it's no crime, he needs to move on. So there is some ability for an officer to detain you on less than probable cause, but it must be a very brief encounter, and it must have specific facts supporting it that a reasonable person would be okay with for an officer to investigate further.